Morning, folks. It's 8:03, and this is the New Hampshire Tech Alliance HR Exchange. My name is Jim Reedy. I'm coming to you from Sheehan Finney, the sponsors of the HR Exchange. Happy New Year. And I, like many of you, has the gift that keeps on giving from the holiday season, a nice long-lasting cold. So my apologies for this nasally type of presentation, but I hope you're all doing well. Liz Tezek tells me that we've got over 400 people registered this morning. Welcome. And I'm glad you don't have to travel far on this cold morning. So we're going to talk today about, as we've done for many years, and typically we've done this in December, but we thought we would wait till January to kick off the new year, a review of the top 10 wage and hour violations, specifically in New Hampshire, as reported by the Department of Labor, New Hampshire Department of Labor. But before we get into the program, a couple of housekeeping things. One is that this program is eligible for HR credits, and those will be provided to you in an email following the program. That email will also include a link for the program itself, a recording, and a copy of the materials. So you don't have to necessarily take copious notes. You can have a copy of the program afterwards. In addition, Q&A. I'm happy to answer questions at the end, or if you want to contact me offline afterwards, I'm happy to talk to you. And you've got my email, jreedy@sheehan.com, which is also at the end of this program. A couple of notes with regard to upcoming programs for the HR Exchange. In February, we typically, in February, it's the Valentine month, and typically we talk about sex harassment related issues. And that this month is, or this year is no different. In February, Andrea Chatfield is going to be reviewing EEOC's updated guidance on discrimination policies and harassment training. And that's because the guidance came out from EEOC in the last year, basically saying that many attempts by employers to do updated policies or training have been ineffective. And some tips from EEOC and from Andrea on improving your on-site training. In March, on March 12th, Karen Whitley is going to talk about discipline and discharge issues, tips from the trenches. In other words, the practical issues in an HR. Sadly, it's a function of the job dealing with discipline of employees and potentially terminating employees as well. And Karen will talk about ways in which you can do that effectively, implementing your policies and procedures, and also avoiding common pitfalls in that area. If missteps with regard to discipline or discharge could result in claims. And this presentation will focus on minimizing the risk in that area. April 9th, Jen Meckel is going to talk about managing leave and attendance under federal and state leave policies. And that's because of the evolution of not only the FMLA, but also the many other federal statutes like the Pregnant Workers Fairness Act, and then changes to, of course, the many state laws out there with regard to paid leave laws and some unpaid leave laws. So that's April. In May, as you know, we do our annual labor and employment law seminar. I think it's our either 36th or 37th now annual event, and that is the Thursday before Memorial Day, and then in June we do a year-end wrap-up. But before we get too far ahead of ourselves, back to the list. The top 10 wage and hour violations from New Hampshire, at least as determined by the New Hampshire Department of Labor. Every year we work with them and go through their statistics, and they're based on their fiscal year, which is a June to July fiscal year, and what their inspectors are finding out there in the field when they're doing their inspections or in response to complaints filed by employees with the Department of Labor. And that's how we come up with the list. And yes, we're in a post-holiday mood now. So in dealing now with looking back on 24, what did that year look like? And again, this is based on information from the last year from the Department of Labor, from their wage hearings, from their inspections, and from their civil penalty assessments and wage adjustments, and effectively outlining the pitfalls for noncompliance, even innocent noncompliance with state laws. And so, as we say, we want to make sure in the year ahead we avoid being on the naughty list. It was a busy year for sure with our friends at the Department of Labor. And I'll show you here in a second what that means. In 2024, fiscal 24, Department of Labor conducted 963 on-site inspections. Now, again, we're in a post-pandemic period, and during the pandemic, they were doing virtual meetings or telephone conferences and the like to do inspections or having documents sent to inspectors and so on. That we've gone back to the pre-pandemic way, which is inspectors actually show up in the workplace, looking at records, paper records, electronic records, and so on. The important thing to mention here is that that 963 inspections was nearly 3 times the number of inspections conducted the year before. That is a significant increase. And you would think that as a result of that, there were an increase in civil penalties and potentially wage adjustments, which we'll talk about in a second. But some interesting statistics in that regard. But usually what comes out of a Department of Labor inspection are civil penalties and the potential for wage adjustments or ordered payments by the Department of Labor to employees and former employees where the department has determined that wages were unpaid. The civil penalties, let's talk about that. So typically, again, the inspections, the inspector will, and for those that have not gone through it yet, typically what happens is an inspector shows up, identifies himself or herself as a representative of the Department of Labor, and they, excuse me, they indicate that they're there to do an inspection, and they typically ask and they provide a list of documents that they want to review. If any of you have not been through it before, please email me separately. We have an email outline, an outline on how to handle a Department of Labor audit. We have one for the state and also for the U.S. Department of Labor. And it's useful guidance, especially if you've not been through it before, and how to respond to the inspector. The bottom line is be respectful, be courteous, and to the extent possible, be cooperative. If you're not, then it does not bode well for you. Inspectors are human. They're there to do a job. Their job is to enforce the protective statutes, wage and hour protective statutes, and also as well as the workers' comp statute. And if you cooperate, things will go better for you. That doesn't mean you have to completely capitulate. You can seek counsel. You can ask questions. And one of the questions you can ask is, why are you here? Now, back in the day, inspectors didn't say, because they typically did random by sort of district or divided up responsibilities throughout the state. They rarely do, if at all, random inspections anymore. Typically, the inspections come from calls by individuals complaining about or asking about issues involving their employer. So you can ask why the inspector is there. Typically, they will say, well, it's based upon a complaint, or we've heard some concerns about this or that. Sometimes they're a little cagey, but most times they will disclose. If not right away, in time they will. But typically what they do is they go through a list. Now, Senator Bradley had a bill that is now law in New Hampshire. It says that when they come in, they stick to basically proportionality, why they originally came in. However, if there's a reasonable extension of why they came in, they can look into those issues as well. And the Bradley bill also talked about that the penalty should basically be in accordance with sort of history and the nature of the violations. The Department of Labor has taken a little bit different position in that regard, and it used to be what's called stacking. The civil penalties would, based upon the history involved, first time $100 per violation, and then the next 250, 500, and so on. Based upon the history of the employer's experiences and the nature of the violations. Labor doesn't do that anymore. Now they basically look at it as the nature of the offenses, and they determine what they think the severity of it is, and they'll assess a penalty at that point. As we'll discuss in a minute, they can also, from there, enter into an informal conference looking at compliance, and with that, reduce the proposed civil penalties. We'll talk about that in a second. But the tail of the tape from last year was the Department of Labor, after discussions with the employers, actually collected just a little over $230,000 in civil penalties. That was a significant decrease from fiscal 23 by nearly half of what they collected. And that's a pretty significant change from year to year. Typically, you don't see that. Typically, you see an increase from year to year. The wage adjustments, like I said, civil penalties are based upon the technical violations throughout the statute, and they cite to the specific statute, and they cite to, as we do in our list, the labor regulations. The wage adjustments are different. That's where the department determines employees have either not been paid or should have been paid, or monies were deducted from them that shouldn't have been deducted, and therefore they've determined these are amounts due back to the employees or former employees. In fiscal 24, they collected $865,000 and effectively distributed that to current and former employees. That too was a good sign because that was a significant increase, believe it or not, from the previous year. In total, between civil penalties and wage adjustments, just over $1 million, which again was a significant decrease from the previous year. That's a good sign. And that suggests somehow that employers certainly, and we know this from dealing with you folks on New Hampshire LaborNet or otherwise, that HR people and those in charge of payroll and the like in New Hampshire do understand it. They do get it. And they make good faith efforts to comply with the law. You spend a lot of time and efforts recruiting employees and trying to retain employees, and you do your very best to comply with the law. So in that regard, we're seeing, and I think that's a good thing. And I also think it's a good thing that the Department of Labor, through informal conferences and otherwise, is working with employers and not being there to punish or necessarily punish employers, meaning they would compromise with regard to civil penalties. One comment in that regard with regard to wage adjustments is typically with regard to wage adjustments and civil penalties, the department will require wage adjustments be paid before they'll discuss any reduction in civil penalties. And sometimes that's a bitter pill to swallow for employers, saying, I don't believe that these employees or former employees are due any wages. Now, you have an opportunity in that regard. In that regard, if that's the case, if you object to the civil penalties, you can go to the Civil Penalties Appeal Board to appeal there. And, pardon me, and if you object to the wage adjustments, you can go to wage adjustment hearings at the Department of Labor. More often than not, employers don't go that route, and they negotiate out at the informal conference. Now, separate from that process where there are inspections and there are civil penalties and wage adjustments, you have individual wage claims. That's wage claims filed by employees against their employer. In fiscal 24, there were 965 wage claims filed by individuals against their employers. That was an increase. So where we've seen a decrease with regard to inspections, a decrease in civil penalties and wage adjustments, we saw an increase in the number of wage claims, individual wage claims filed by employers, employees against their employers. And so that tells me that, again, you've got a situation where employees either are dissatisfied somehow or misunderstand the law, and they've contacted the Department of Labor and tried and filed a wage claim. It's a very simple process that an employee can file the claim either in Superior Court, which is rarely done, or with the Department of Labor. And they call into the Department of Labor, they fill out a form, the claim goes to the employer can respond by saying, we agree and we'll pay it, or we object. If there's an objection, there's a hearing. The hearing is usually in person at the Department of Labor. It's a back and forth between employee and employer, and the Department of Labor has a hearings officer, and they determine based on the evidence whether or not wages are due, and they can award wages based on the claim. And there's an appeal process that's involved as well, but that's the back and forth. But we did see an increase in that regard in fiscal 24. So a lot of changes, some for the better, some for the worse. But every year when we look at the top 10 wage and hour violations, the top 10 list, we see some of the common ones, and we see others that change from year to year. And most of these are some that you would recognize. And they're moving around of the categories from year to year. But again, what you want to do is you want to stay off of this list if at all possible. And I think the way in which you do that is conduct an internal audit of your wage and hour practices and make certain that you are in compliance. Now, I think the challenge is most employers uh, uh, these days have operations beyond New Hampshire. And of course, the laws in Massachusetts and Vermont and Maine, the contiguous states, or beyond. I was dealing with a client yesterday, a multi-state client, dealing from California to the East Coast, and the very different laws. So there is certainly a challenge in that regard. But if we focus just on New Hampshire, we'll go through the top 10 list. But certainly it's more and more it's a challenge as employers have operations beyond New Hampshire. But if we focus just in New Hampshire, there are enough challenges here to make certain that we've got things in order. So top 10 list, starting with number 10. This is an interesting one because it applies to principally hospitality employers, but interesting development in that regard. Let me just take a quick sip of magic coffee here. Tips. Now, this is an outgrowth of, tips have been around forever, and we'll talk about that in a second, but we've seen this since the pandemic when more and more you had the outgrowth of the flip screen, where you go get a cup of coffee at a coffee shop, or you go to a restaurant or take out, and the cashier flips the screen. Here's the total, and here's an option. 10%, 15%, 20%, or other for purposes of the tip. And we've grown accustomed to that, but more and more there's actually been a pushback saying, well, wait a minute. It's not like I'm sitting at a restaurant and being served by someone. It's just literally you rang me up and you're not even providing the service necessarily. And why am I providing you with a tip? And then if I provide you with a tip, where's that going? We'll talk about that in a second. But in the meantime, let's deal with the traditional tip. A tip means money given by a customer to the employee who performed the service, the server typically. And that, as a matter of law, is the property of the employee. Tipped employees of certain employers, and those employers, again, would be restaurants, hotels, bars, cabins, believe it or not, is in the definition of the law, is a tipped employee, can be paid a sub-minimum wage, which is 45% of the then current minimum wage, as long as when their tips are added, and the tips have to be at least $30 a month. You can see how antiquated that law is. As long as that equals or exceeds the then current minimum wage, which again is $7.25 on a federal level and in New Hampshire. That's a tipped employee. Now, the Department of Labor has gotten involved in recent years because of the flip screen issue and sort of the multiplicity of tips and who's receiving tips, but also the notion of tip pooling and tip sharing. Tip pooling is amongst similarly situated employees. So that would be your servers in a restaurant, bartenders in a bar. Those are tipped employees, and that when you tip, typically in situations like that, those servers or those bartenders can decide amongst themselves to pool their tips. So at the end of the shift, they then divide it up. Now, a tip pool has to be purely voluntary. It's among similarly situated tipped employees, and they decide who's in the pool, and they decide how much they're going to contribute individually, and so on. Under New Hampshire law, and we've been through this a number of times. Jed Meckel and I and others in our group have been through this with the Department of Labor. The pool has to be purely voluntary, and the participants can opt in or opt out. The employer can decide, will suggest a customary amount. The employer can administer the pool, and the employer can help distribute from the pool. But it cannot coerce or require tipped employees to participate in the pool. A tip sharing arrangement is a little bit different. Tip sharing is between tipped employees and non-tipped employees. And what do we mean by that? Go to your typical restaurant situation where you might have a server, but the server doesn't act alone. He or she may take your order, but then you have an expediter who might bring it to the table. You have a person who clears the table before you get there or after you leave. You have a host who brought you to the table, and so on and so on. So there are a lot of people that contribute to it. And so therefore the tipped employee can say, look, I got the tip because of the terrific service you got from the team of people. Therefore, I can decide to share my tips, whatever percentage I decide. And usually, again, it could be customary, suggested by the employer, but the tipped employee has to decide whether on a daily basis to opt in or opt out. And typically, once they opt in, they stay in, but they decide what percentage they want to share. And sometimes they can say, today, I don't want to share as much because I didn't get as much in tips and so on. It can be administered by the employer. The employer can deal with disputes and also can distribute the amounts at end of shift and so on. But the important thing to mention there is tipped employees can get the tip credit, meaning they can be paid less than minimum wage. Non-tipped employees can get the tip share, but they must be paid even before they receive the tip share. They must receive their at least the minimum wage. The problems that labor has found in the last year is that managers and supervisors participating in the tip pool or the tip share, that's not permitted. And then further, that they found that some of these tip pool or tip sharing arrangements were mandatory or coerced, and employees were not able to decide whether to participate or not. They were forced to participate, and they couldn't opt out, and other issues. So labor got really involved with that. We've had some changes to the law that have been beneficial to clarify in the last year, to clarify who could participate and the arrangements between employer and employee, and that has been very, very useful. But the bottom line is to proceed with caution here. Employers that have these arrangements, and again, you must be an employer that can have a tip credit or tipped employees, adopt a policy, explain that policy during onboarding, post that policy, deal with questions and disputes in a timely manner, and avoid pressuring employees or retaliating against those who do not participate in the pool. And any questions in that regard, again, we deal a lot with hospitality employers in this regard, but if you are someone who doesn't fit within the definition of a tipped arrangement, you have to proceed with caution there too. There's been a recent guidance from the Department of Labor. If you talk about your coffee shop or your convenience store and so on and tips, I'm happy to talk with you offline about how those are handled because it's a little bit different. This is an interesting one. This is number 9, and it is employers' failure to have a joint loss safety or joint loss management safety committee. It's required as a matter of law. It's in our workers' comp statute. And again, probably 10 plus years ago, it changed as to the number of employees that you had to have on these committees. It's now 15. It's been 15 for a number of years now. If you've got 15 or more employees, you must have a committee. And what is the purpose of the committee? To meet, to review and address workplace accidents and related safety issues. Now, there's another element on this, or violation on this top 10 list, that relates to this, but this is simply just having the committee. So, and who is on the committee? It should be equally represented by labor and management, meaning management and non-management employees. And they should meet at least quarterly. And they hold meetings at least quarterly. They maintain meeting minutes. They're posted and filed, and they're available for inspection by the Department of Labor. And they also update their safety plans and reports as necessary. Now, can that simply be your OSHA 300 log? It certainly can. But again, what you're going to have is when you have workplace accidents, again, your first report of injury in New Hampshire under our workers' comp statute, you've got that record, and also some record of showing where you've adjusted or addressed a workplace accident or hazard or safety situation. Pretty straightforward. This one, number 8, has been a bit of a bugaboo for employers in recent years because of two things. One is, I think, the pandemic. I think the other is with regard to an interpretation from the Department of Labor related to the advent of remote work. The law, as you know, says that, and this is RSA 275-43A and a related regulation, if an employee shows up, reports to work at the request of the employer, and then there's no work for them, as you know, the option is the employer can either put the person to work and pay them their regular rate for the hours worked, or pay them 2 hours for simply reporting to work. Now, the employer can notify the employee, don't bother showing up. And if the person still doesn't show up, then that's fine. There's no harm, no foul. If the employer attempts to notify the employee and the employee still shows up, then it's, again, you put them to work or pay the person for the minimum of 2 hours. What's the purpose? If you go look at the genesis of the statute, the purpose of this was, given the size and the sort of geography of New Hampshire, typically your longest commute to work historically in New Hampshire was 1 hour. So that's 1 hour in, 1 hour home, and effectively paying the person for the inconvenience when they had an expectation of working certainly 2 hours or more in the workplace. So that's why it was known as sort of the bad weather or show up rule. More recently, the Department of Labor expanded this approach to the rule basically with the advent of remote work. Again, pre-pandemic, the average number of employees in the U.S. that worked remotely was 6%. In the zenith of COVID, it was upper 60s%. It's now basically down to 35%, 35% of the U.S. workforce, at least in part, works remotely. And so the Department of Labor took a position that said that if an employee engaged in work off-site, effectively at the request of the employer, they should be paid daily a minimum of 2 hours. Now, that was contrary to the legislative history, and we've worked with the Department of Labor on a legislative fix, and I'm here to report that a very positive development. We've worked with several groups and the lobbying group at Sheehan Finney, and we have a Senate bill that has been proposed to basically say it is when the employee, at the request of the employer, physically shows up at the employer's work site and not dealing with the remote employee. However, remember, the remote employee has to be paid for all hours worked remotely. So if they're working, you pay them. So again, this applies to the private sector, public sector employers not covered by this statute. There were some other carve-outs as well. One you see in the statute, if you're looking at it, applies to ski employees. We were part of that change years ago, dealing with for those that ski or snowboard, you understand in ski school, someone shows up to teach a class, there's not enough people for the class, they ski off and enjoy the day. Should they be paid a minimum of 2? The answer is no. So there's a carve out for that. But and there are a few other exceptions too, like if the employee on his or her own decides to go home to care for personal illness or so on, they're not paid the minimum 2 and so on. So, but I'm just pleased to report that we've worked with labor and they've been very cooperative, and we've come up with language to address this situation. In the meantime, still pay attention to that. If you can notify your employees electronically or otherwise, don't come in. And if they do come in, you have the opportunity of putting them to work or paying them a minimum of 2. The other exception, of course, would be if the employee knows at the time they were hired that their workday is not going to exceed 2 hours. It's going to be like the person comes in to fix your boiler or check on this or that. It's only an hour. Then you would only have to pay them for that hour. But just being clear at the outset what the expectations are. And so that's effectively what I'm saying here too. 7. Failure to have a workers' comp policy. This one is pretty simple. If you've got one or more employee in New Hampshire, you have to have a workers' comp policy. And surprisingly, labor found in their inspections in the last year that some employers let that comp policy lapse or failure to secure it altogether. And if they do, that's pretty significant, because if you don't have workers' comp insurance, not only could you be facing civil penalties, but you could have the unfunded liabilities of paying for the person's medical bills and lost wages. And you never want that situation. So even if you have a very small operation with, say, 1 or 2 employees, or even part-time employees, you have to have a workers' comp policy. So again, along with other things that you do with a self-audit and checklist, make certain that you know when that policy expires, and well in advance of expiration, you're re-upping, but also that you're cooperating with your carrier. You're paying your premiums in time, and you're providing them with the adequate information. First, report of injury when required, and then also cooperating with the employer to avoid the carrier from dropping you from coverage, which rarely happens, but you don't want to have a situation in that regard. Number 6, this one is failure to pay all wages due, including short breaks, overtime, shift differentials, and so on. This is a timekeeping issue. So we're going to have another related one where it's a delay in payment, and there's yet another related violation related to specifically types of breaks, but this is basically timekeeping. And it's making certain that regardless of what method you have, what HRIS system you have or otherwise, that employees are following it. Because remember, the statute says that employers should keep an accurate record of all hours worked for employees. And typically we're talking about hourly and salaried non-exempt employees, but keeping a daily record of time work commenced to time work ended, with any bona fide break in between. And we're talking about short breaks and so on, which I'll talk about in a minute. But those records, keeping that accurate record, and as a result of that, if you don't keep that record in the continuum, that employees would not be paid all wages due. So making certain that those things are in there. Who's going to keep the record? The employee keeps the record, but the statute says the employer does, right? So the employee enters his or her time, and the employer has to check to make sure that that is accurate. Now, we've talked about this before. The other part of that is what happens when there are changes to the statute. Well, the statute talks about changes to the time record, rather. When that happens, the statute says that the employer can make a change to the record, the time record, that is. Say it's a missed punch. Say it's an employee reports, oh, by the way, I took lunch today, or I didn't take lunch today, or, oh, there's some additional time. I showed up and did this. But one, you want to avoid a automatic timekeeper, meaning one that just punches the employee in or punches the employee out at end of shift. Don't have an automated record in that regard. Do not have an automated after 5 hours automatically punching a person out for break. That's not an accurate record of all hours worked. It must be unique to that employee and that per employee's situation. So what if the employee shows up early and starts working, but then punches in later and says, oh, by the way, I actually showed up 40 minutes early, and this is what I did, and enter that time. Anytime there's a change to the time record, the employee must initial the change. So if the employer is changing the record, whether at the request of the employee or not, the employee must initial the change. Well, in the advent of or where we are with regard to electronic timekeeping, what does that mean? Some way in which there is a record that the employee acknowledged the change. So can you initial time record? Perhaps, but otherwise it might be an email or some acknowledgement that should be kept in the file that the employee acknowledged the change to their record at the time. So focus on how time is recorded, use the technology properly. And then the other thing to mention is, what if the employee does not use your HRIS system, your timekeeping system, your fob, your time card, and so on, and they have some extra time they have in there? They wrote it on the back of a napkin. They sent you an email. Is that an accurate record? Should that be considered? And then the short answer is yes. The Department of Labor has taken the position, both U.S. and state, that whatever the method is, if the person reports something, and that's additional time, if you can, if as long as it's legitimate, and I don't know how you could necessarily disprove it, perhaps with cameras or fobs, you must pay that person for that additional time. So encouraging employees to keep your time system, keeping managers and supervisors to monitor to make sure daily that that time has been entered, and when it hasn't, addressing the situation in a timely fashion with the employee. Number 5, we're back to a safety plan. Failure to have a safety plan or safety summary form on file with the Department of Labor. So it relates back to, we have a committee, we didn't have a committee, but that committee has to keep the records, and the records are recording injuries and illnesses, and what did the employer do in response to any known workplace hazards. You must document your safety policies and compile a written safety program. And what labor found in the last year was that many employers neglected to maintain their safety committees and the safety records, and that represented a civil penalty. The question that came up during COVID a lot was, wait a minute, am I supposed to log that as well? And there were sort of a difference of opinion, but if there was an outbreak of COVID in the workplace, just like there was perhaps of flu or, name other sort of airborne illness and so on, if there was a known hazard, you could certainly keep that as a record, but typically it's a slip and fall in the workplace, a defective device that resulted in workplace injury or illness. But again, you've got a safety program that the committee will look at, and you've got your reports, and then you've got your reports that basically say what we've done to correct that known hazard. Again, that's for employers with 15 or more employees that have to maintain a written safety program. Safety program has to be reviewed and updated at least every 2 years. You keep the record of that. You can submit it electronically as the Department of Labor. And since 2011, if you filed that plan, you don't have to continue to file. You just have to keep those records updated with the Department of, keep it updated in the event of an inspection. Paying later than the designated payday is number 4 on the list. And that is a perennial top 10 violation on this list from year to year. In that regard, it happens in a number of different ways. Failure to pay wages on time, or failure to pay the full amount due because of unauthorized deductions or other issues. The one I think that is most common that comes up here is time entered late by the employee. So you've got a payroll close. So today is Wednesday. Say payroll closed yesterday on Tuesday, so for employers to calculate payroll and pay it, say, on Thursday or Friday. And the employee surfaces today and says, oh, by the way, there's some additional time I didn't enter, or could I add this additional time? And historically, what employers said was, and even if it was a small amount, said, and even if the employee agreed, we'll pay you, and we'll put that time in the next regular payroll. Labor says you can't do that. You must be paid within 8 days of the close of the period in which you perform the work. So the statute talks about, at least that the period of time in which you have to pay the wages. Labor has taken the position for many years that if you have that additional time that should have been paid in that pay period, you cannot wait till the next pay period, and there can't be a waiver by the employee. Instead, you must cut a manual check or otherwise pay the person electronic fund transfer, direct deposit, however it is, but it's out of cycle. And what if you do with that? You have that situation where the person is chronically saying, hey, by the way, I've got some additional time, and that represents a cost to the employer having to pay that out of cycle cost when the person should have entered the time in a timely, complete and timely fashion. Can you discipline the employee? You can, but proceed with caution. What you should do is really, again, train the employees on timekeeping, train your managers on monitoring on a daily basis to make sure all time is entered. But in the event that there's additional time that needs to be entered, it must be paid within that same 8-day period. So oftentimes out of cycle, and a separate check subject to all withholdings. The other issue that comes up is improper deductions. And there's the list in the statute of proper deductions, RSA 275-48. And any deductions from wages must fit within the I think it's 12 opportunities or options within that list. So you'll see the definition in there and the guidance in there, but the bottom line is you can't push it off to the next payroll, and even if the employee agrees to it, even if it's a small amount. Undocumented workers. Well, certainly this is a hot button issue, right? With the national and even local discussions with regard to undocumented aliens in the U.S. This is not unique to the last 4 years, but it has been a hot button issue in the last 4 years. Employers, even in New Hampshire, have been desperate to fill positions. We have a low unemployment rate. We hover at about 2.5 to 2.7%, full employment being 4%. So this is a hot labor market, and as a result, some employers, labor found, were not diligent about completing the I-9 form. So remember, I-9 is a federal statute, but we have a state statute, and the state statute is RSA 275A, and it's called the Citizens Job Protection Statute. And basically, it says that employers in New Hampshire cannot hire someone who's not legally cannot work in the U.S. So when does that happen? Well, at the time of hire, when you've hired someone, they must complete the I-9 form, and that means truly complete it, which is presenting documents showing proof of identity and authorization to work in the U.S. And the I-9 list, as you know, is A, is both identity and authorization to work in the U.S., B is identity, and C is authorization. And you must have either something from A or something from B and C on the list. The employee can decide which they're going to present to you, but it must be an original document. It must appear to be genuine on its face. And should the employers keep a copy of it? Well, the statute doesn't require that. We do recommend that because as you fill out the certification on the I-9 form that you've looked at the document and it appeared genuine on its face, you want to, in the event of an audit by the Department of Labor, either USCIS or the New Hampshire Department of Labor, you want to show this is the document we looked at. Do you have to be a document expert? No, it should, but you should look at it and say, does this appear genuine on its face? But again, this must be fully completed at the time of hire and maintained by the employer. In that regard, sometimes there's the issue with regard to the 3-day rule. The 3-day rule only applies when the person has lost the documents or needs to get a replacement. My rule of thumb, our rule of thumb is have it at the time before the person commences work, that you've completed the I-9 and you're not waiting for days afterwards. So that is the safest position to have. And again, you've got that all together, but to avoid problems, we do recommend keeping copies of the support documents that have been provided and making certain that the I-9 is completely filled out properly. And the most common mistakes are, putting the date of hire and the date of completion of the form in the wrong places and so on. John Wilson has talked about this before, and his team helps going through an I-9 audit. You can do an I-9 audit on your own as well, but just make certain that the documents are completed at the time of hire and before the person commences work for you. In the event that later you find out that you've got documents that are either incomplete or with error, you can correct it at that point and keep a copy of that correction in your I-9 audit file for purposes of inspection. Number 2 on the list is failure to keep accurate records of all hours worked. Well, haven't we talked about that before? Yes, we have, but what we're focusing on here is the true and accurate record dealing with short breaks and so on. Meal breaks and short breaks. So a short break, for purposes of the FLSA, the federal statute, which is applied in New Hampshire as well, is any break shorter than 20 minutes in duration. And so anything shorter than 20 minutes in duration is considered to be a continuous hours worked. And then with regard to meal breaks, we know in New Hampshire, it's after 5 consecutive hours of work in a workday, the employer must permit the employee to take a meal break. Now, labor's taken a sort of a tougher position in this regard, and basically saying it must be at 5 hours, and that you cannot have a meal waiver. What we say in that regard is, especially if someone's working a 10-hour or 12-hour shift, do they have to take another 30-minute unpaid meal break? As you know, in New Hampshire, you can require or permit the employee to eat at their workstation. If that's the case and the break is less than 20 minutes in duration, meaning free from work, that person must be paid for that meal break. So just maintaining that, having supervisors check that. This is not a nutrition statute. This is basically an hours work statute, but labor does take a serious look at short breaks and meal breaks. and that should be recorded as a part of the daily time record when the break was greater than 20 minutes or when a meal break was taken. And again, that is something that has been a hot button issue for labor. And the question is, does it have to happen precisely at 5 hours? It says after 5 consecutive hours, but we recommend keeping it within a 5 to 6 hour to avoid situations or problems. And again, labor can look back up to 3 years for potential violations. So you want to make sure your records are complete and accurate. And the number one worst violation from fiscal 24, according to the friends at New Hampshire Department of Labor, failure to have written notification of a rate of pay. This one is, this has been on the list every year, I think, for as long as we've been keeping the list. And it's an easy one to satisfy. But labor found this as the number one violation last year, meaning at the time of hire, well, the statute RSA 275-49 requires that you give written notification of the employee of these elements: the rate of pay, pay period, pay date, and the general description of fringe benefits. Does it have to be into the the bug dust for the specifics of your health insurance, your the handbook or policies or onboarding through HR? But there must be a written document: pay rate, pay date, pay period, and a general description of fringe benefits. And it must be signed by the employee, not agreeing to it, but acknowledging receipt. And that must be maintained in your personnel files for inspection by the Department of Labor. And when also does it have to happen? You also have to have a subsequent document, again, acknowledged by the employee. And it can't be an email where it just simply is a receipt that the person received the email. It must be an acknowledgement. I acknowledge I've received this email that says that in advance of any change to compensation, benefits, pay date, pay rate, pay period, in advance of that change, the employee receives a written notification that he or she must then acknowledge, and that is placed on the personnel file. Again, so at the time of hiring, and then anytime there's been a change up or down to compensation and benefits and pay arrangements, that must be as in the file for purposes of inspection. And that's something, again, that would come up in your HR compliance audit or checklist. So that's the list. We did it in just under an hour. I think it's a very helpful list. I think what I found was most interesting is this list was, one, the number of significant increase in the number of inspections, but on the positive side, the decrease in the number of civil penalties, the decrease in the number of wage adjustments. On the other side, there was an increase in the number of wage claims filed by individuals. We didn't speak to the outcome of those hearings, but any hearing you would do has at least some risk involved and potential cost involved, especially if you have representation. And I think the other thing, the positive with regard to the potential legislative change in the area of reporting time, we ask you to stay tuned on that, and we may need some legislative support and even testimony on that change. But right now, labor is agreeing with us, which is a very positive development. And the other thing to be aware of is with regard to tips, if you're a tipped employee, how that is interpreted by labor, and then just the other things on the list. Again, our advice is go through your own HR audit, check these things to make sure you're good in compliance. Again, if you have any questions, please reach out to me. I'm happy to help to respond to simple requests. It's probably better that you send me an email, that we not meet in person, so I don't spread this wonderful virus to you. But I hope this has been helpful. And because of time and also my lack of a voice here, why don't you send me an email with any questions, and I'm happy to respond. But in the meantime, I hope that's been helpful. I want to thank our friends at the Department of Labor, and specifically John Garrigan, and Lexi Rojas from Department of Labor, and also Jen Meckel for her assistance with this update. I want to thank you for your time today. We had well over 400 people registered, and great participation today. And again, reach out to me with any questions. I'm happy to respond. But in the meantime, thanks for participating. Liz Tezik will be in touch. She'll send you a copy of this program along with your HR credits. And we look forward to you joining us next time. Thanks so much.